I've been covering this Washington beat for decades now, and let me tell you, what happened just yesterday has me fired up like a brush fire in dry grass. Members of Congress, led by that straight shooter Representative Andrew Clyde, along with senators and House reps from both chambers, sent a formal letter straight to Attorney General Pam Bondi, putting the Department of Justice on notice. They're demanding the DOJ drop its defense of the National Firearms Act registration requirements for suppressors, short-barreled rifles, short-barreled shotguns, and other items now that Congress zeroed out the tax in President Trump's One Big Beautiful Bill Act. This isn't some backroom whisper. It's on the record, signed and delivered. But here's the rub. The DOJ is still fighting in court to keep that registration scheme alive. Who benefits from ignoring Congress's clear intent? We're talking about the heart of the Second Amendment here, folks. Personal freedom versus government overreach. Stick with me through this broadcast, because by the end, I'll lay out the hidden agenda that's got hard-working gun owners across this country asking, what in the Sam Hill is going on in Washington? We've got the facts, the history, and the warning signs ahead. Well, folks, let's start with the plain facts of what went down yesterday. A coalition of over 40 members of Congress, that's House reps and senators alike, fired off a strongly worded letter to Attorney General Pam Bondi. Listen to this key part. They're informing the Department of Justice of Congress's position that the National Firearms Act's registration and transfer rules for these zero-tax items should no longer stand. Why? Because back in July of 2025, President Trump signed the One Big Beautiful Bill Act, which set the excise tax on suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons to $0 flat. Now here's where it gets interesting. The letter points out that the National Firearms Act, way back in 1934, was upheld by the Supreme Court only because it was tied to taxing power. That $200 fee, which today would be nearly $5,000, adjusted for inflation. It was a tax to track and discourage certain firearms. But Congress just eliminated that tax for these categories. No tax means no justification for the burdensome registration. Fingerprints, photos, home addresses, serial numbers, all sent to the Bureau of Alcohol, Tobacco, Firearms, and Explosives. These lawmakers are chastising the DOJ for defending the old rules in ongoing court cases. They're saying, plain as day, that keeping registration now would turn the act into a pure gun registry, something Congress never authorized and even prohibited in the Firearms Owners Protection Act of 1986. Signers include heavy hitters like Andrew Clyde, Steve Daines, Mike Lee, Chip Roy, and dozens more. Real champions for gun owners. This comes on the heels of lawsuits from groups like Gun Owners of America, challenging the remaining rules. Common sense tells us, if there's no tax revenue, how can it still be a tax law? It's like requiring a fishing license but charging nothing. Eventually, folks would ask why the paperwork at all. I've been around long enough to know this kind of pressure from Congress doesn't happen every day. It's a darn shame the DOJ isn't already on board, but this letter puts them on notice. One has to ask, is this the momentum we've been waiting for? All right, now let's roll up our sleeves and get into why this letter packs such a punch, and why the DOJ's resistance don't sit right with me one bit. Back in 1934, during the gangster era, Congress passed the National Firearms Act under its power to tax. The Supreme Court in Sonzinsky v. United States in 1937 said the registration was okay only as a way to collect that tax. Another case, United States v. Constantine in 1935, made clear a tax that brings in no money ain't a real tax. Fast forward to 2025, the One Big Beautiful Bill Act zeroes the tax on these items. Congress's intent? Clear as a mountain stream, link the tax and registration so tightly that removing one guts the other. These lawmakers spell it out. The requirements are inseparably linked. No tax stamp means no need for the Bureau of Alcohol, Tobacco, Firearms, and Explosives to track every serial number and owner detail. Firefox, but here's the hypocrisy that gets my goat. The Department of Justice, under Attorney General Bondi, is in court opposing this view. They're defending registration as if the tax never went away. Follow the money, or lack thereof. Who benefits from keeping a federal list of who owns suppressors for hearing protection on the hunt, or short-barreled rifles for home defense? Not the everyday American protecting their family or enjoying the shooting sports. It's like the government moving slower than molasses in January, clinging to power the founders never gave them. James Madison warned in Federalist 51 that men ain't angels, so we chain government with the Constitution. Thomas Jefferson said, "Bind them down from mischief." This letter is Congress trying to reapply those chains. Yet the DOJ pushes back, risking turning a tax law into a full-blown registration regime, the kind hard-working folks have fought against since the Revolution. And don't get me started on the parallels. When Congress zeroed the Obamacare penalty, the DOJ refused to defend it. Why not here, in defense of the Second Amendment? President Trump called himself the most pro-Second Amendment president ever. This is a chance for his DOJ to prove it. Instead, they're flip-flopping more than a fish on a dock. This deep dive shows a hidden agenda: bureaucratic inertia preserving control over law-abiding citizens. It's a darn shame, and it reminds me of when agencies think they're above the people who elected Congress. Now, folks, let's look ahead. Because if the Department of Justice ignores this congressional letter, we're in for rough waters that could drown Second Amendment freedoms. The letter urges Attorney General Bondi to switch sides in litigation, adopt Congress's position, and stop defending rules that lost their constitutional footing when the tax hit zero. If they don't, we're staring at a future where federal gun registration expands without any tax justification, a slippery slope toward more overreach. Lawsuits are already rolling, backed by gun owners of America and others, arguing the registry can't stand alone. Courts could rule soon, and with Supreme Court precedent on taxing power, gun owners might win big. But if the DOJ digs in, it sets a dangerous pattern: agencies rewriting laws Congress passed. That erodes trust in government faster than rust on an old truck. Imagine your grandkids facing even tighter rules because bureaucrats wouldn't let go. Or worse, this hypocrisy giving anti-gun crowds ammunition to push more controls. On the flip side, if Bondi listens, drops the defense, aligns with lawmakers, we could see suppressors treated like regular firearms accessories, short-barreled options easier for homestead protection, all without the red tape. It's a grand slam for freedom, upholding President Trump's legacy. Wireless here is hard-hitting. This ain't about safety, it's about power. The Second Amendment isn't going anywhere. It's what makes America, America. But agencies acting like unelected kings threaten that. Congress is shining a light, but will the DOJ step into it or stay in the shadows? Folks, stay vigilant. The consequences shape not just the National Firearms Act, but federal limits for generations. The system's got its flaws, deep ones, with bureaucrats sometimes forgetting who they serve. But we're here to shine a light on it. It is high time for Attorney General Bondi to fall in line with lawmakers and gun owners.